On your British program, Hard Talk, BBC Hard Talk, Joan Donaghue was on the program, and I will say it, and I have no fear of saying it. She flat out lied. It was a flagrant, bold faced, shameful, and shameless lie when she stated that the court had not found that Israel was plausibly committing genocide. That was a flat out lie. I've just finished a 10-page single spaced analysis of what the court found on
Mhm.
January 26th, and I hopefully will be able to post it and to challenge Joan Donaghue on that, the American judge.
I don't want to I don't want to interrupt your train of thought there, Professor. But just a quick point as a lawyer, what she said on the hard talk, which is absolute rubbish. She says that she made the argument, or the interim order should be interpreted that the Palestinians have a plausible right to be protected from genocide. I mean, that's rubbish. You
Well,
don't have
look,
a plausible right to be protected. You have an absolute right to be protected from genocide. And
I,
but that's the argument she's making.
well, I don't think she was making an argument, and I'm being very serious about that. This was a careerist, a wretched careerist who was trying to uh, protect herself as she left the ICJ and is now looking for a job in the United States.
Hmm.
The basic facts are very simple and they are irrefutable. The basic facts, let's work backwards. First of all, she didn't do anything. There was a vote on that, uh, on those provisional measures. So it was 15 judges versus two. It was 15 judges who signed on, and she had no business speaking for all 15 judges. But let's put that aside for a moment. Let's take the very essential, basic issue. Let's work backwards instead of forwards. The court issued provisional measures. Under the court's jurisprudence, you cannot issue provisional measures pertaining to the Genocide Convention, which is the only convention that was at stake in these hearings. It wasn't about the laws of war. It wasn't about IHL. It wasn't about war crimes. It wasn't about crimes against humanity. It was only about one thing. It was about genocide, the Genocide Convention.
Hmm.
You cannot issue, on the basis of the court's jurisprudence, you can't issue provisional measures in a case around the Genocide Convention unless you have plausibly proven that Palestinian rights were at risk under the Genocide Convention. And the Palestinian rights couldn't have been at risk under the Genocide Convention unless Israel was plausibly committing genocide. That is so simple, so basic, so irrefutable. Once they once they indicated the provisional measures, it was an acknowledgement that Israel was plausibly committing genocide that put Palestinian rights under the Genocide Convention at risk, which is to say, Palestinians were facing a plausible genocide. If South Africa had not proven that, there couldn't have been provisional measures. That's the whole point. Now, the first provisional measure The first one, if you look at your, no, you don't have it because you don't have the court order.
I've got it here. I've got my application here. I don't know if we could. You're looking at the screen, the relief that is sought by South Africa, right?
Right.
Let me see if I can share that. I may have it on me. Let's see if I can share it.
If you look at the first provisional order of the court, the very first provisional order, I'll just read it to you.
Yeah.
Okay, here. Article 2 of the Genocide Convention prohibits, Article 2 prohibits what is called acts of genocide. And there are several types of acts of genocide. There is outright killing, there is endangering the civilian population. I'm not going to go through it.
Yeah.
Article 2, the first provisional measure reads, the court considers that with regard to the situation described above in the court order, Israel must, in accordance with its obligations under the Genocide Convention in relation to Palestinians in Gaza, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of this convention. That is to say, if the provisional measure states that Israel must take all measures so as to not breach Article 2, then South Africa must have demonstrated that there was a plausible danger.
It's the genocide.
That Israel was breaching Article 2. If there was no plausible danger that Israel was breaching Article 2, which prohibits acts of genocide, they could not have indicated that provisional measure. There has to be, according to court jurisprudence, there has to be a close link between the provisional measure and the right that's plausibly being violated. Well, what right was plausibly being violated? The right protected under Article 2 against acts of genocide. So her claim that we did not establish that Israel was plausibly committing genocide,
ridiculous.
It's completely ridiculous, because then you couldn't have issued provisional measures to protect the Palestinians from what? To protect them from Article 2, acts of genocide.
It's like a rule nisi, in an interim order or relief that you're seeking before you get the final order. You get the interim order, or the equivalent from what I can see as a criminal defense lawyer, where the prosecution has established a prima facie case before you go for trial. But the one disappointment that a lot of us felt, and probably it's because of the fact that the ICJ cannot implement orders, is the primary relief being sought by South Africa in the application, the first relief being sought, that the state of Israel immediately suspend its military operations in and against Gaza. You predicted that wouldn't happen in any event. But my issue is that because of the fact that this eventually has to go to the United Nations Security Council, and in the inevitability of a provisional ruling, they would simply veto it. I mean, does the ICJ not have that particular power in order to grant it relief?
It has that power, and it acted on it in a very bizarre way. I don't want to go into details. It acted on it with Ukraine and Russia, but I don't want to go into the details. In general, it has not called for a cessation of military activities. It has not. My colleague Muin Rabbani has read through the old cases. I have not read through all of them.
Should it principle have not? Should it not have done that? I mean, from a principle point of
I,
view.
I didn't think it was possible for the very simple reason that because Hamas wasn't before the court, it would have been a one-sided, a unilateral calling for cessation of hostilities. It couldn't have been mutual because the court didn't have the power to make it mutual because Hamas is not a state and it's not before.
Well, what was the difference between the Ukraine and the Russia? Was that because there were allegations?
The Ukraine was so convoluted and so bizarre. It was completely ridiculous and it was completely political. And we all know that that's how the courts operate 99% of the time. Surprisingly, in the case of Palestine, it didn't, I have to say. I thought it was this thing was dead in the water. I was totally shocked by the vote. Though I have to say, not that I keep score, I claim now that I was half wrong on the American judge. I said there's no possibility in the world that she's going to vote that Israel was plausibly committing genocide. Well, she did, but guess what? She then took it back. So I think I get half a point. I don't get a goal, but I get something out of that. Now, if we turn, I have to watch the time. If we turn to what happened in the past week, formally speaking, you could say it's a tie because South Africa claimed that there is a imminent irreparable harm being done because of the starvation. Israel claims that's not the case, but there's a very big difference, a huge difference. And here is the difference. The difference is South Africa quoted UN authorities. It didn't quote its own government. It quoted international humanitarian organizations and it quoted UN organizations. What did Israel quote? The second person who came up, I guess her name was Torkeman. The second person who came up, all she did was quote generals, Israeli generals and Israeli officials.
Yeah.
So you cannot reasonably say that what's called in law evidence with interest, namely quoting your own government saying, hey, we aren't doing this, with evidence against interest, namely this was UN officials, have no dog in this race, UN officials, Secretary General, head of World Health Organization, head of World Food Program, Undersecretary for Humanitarian Affairs. They have no dog in the race. And they're saying that a mass starvation is imminent. So at that level, even though formally it's statement versus statement, in reality, it's statements with interest versus statements without interest. So you can't compare the two, in my opinion.
In fact, we South African case, and I'm not praising our government, but we did an 85 page application with about 500 footnotes.
Yeah, with all UN sources.
Israel didn't produce a written document. They argued from the bar, so we don't have a written document.
They did produce one, but it hasn't been publicly made available. They had this. You will recall they always refer to, if you look at tab 1, if you look at tab 2, if you look at tab 3, they're referring to a document that was submitted to the court, but for reasons I don't know, it hasn't been made publicly available, that document. My guess is the reason is obvious, because it only cites Israeli sources, which is
what? Yeah, no, I see. She cited the lady who was doing the argument. We had, I believe you know John Dugard, right?
Yes, I know Mr. Dugard. Yeah. Professor Dugard, yeah.
Professor Dugard. Since the application has happened, and I know times. Go ahead.
One last thing on that point.
Sure.
Now, I was informed this morning. I can't say with authority. I'm just saying I was informed this morning that something unusual happened. The court called back the South African delegation to answer Israel's claims yesterday. Now, I'm not aware of a precedent like that, But as we both agree, it was on the surface, somebody is clearly lying
Of
because
course.
it's black and white. We say there's a starvation, famine occurring because Israel is denying supplies. You say we're flooding the place with supplies.
Yeah.
So something is not right there. And now the court has apparently called back the South African delegation. This is what I'm told. I was told this morning to answer the Israeli claims. Now, I would say that's an unusual thing for several reasons. Number one, I don't know the court protocol, but I suspect that's because the president of the court is from Lebanon. I do not believe the American judge would have done that. And
Mm-hmm.
he probably exercised his prerogative, which is buried somewhere in the court protocol, that he has the right to do that. That's the only explanation I can see.
I wasn't aware of that because it hasn't certainly been reported here.
I
But
thought it from the inside, but I could be wrong. I could be wrong. The
yeah,
second thing, which is critical, is if that's the case, now the whole of the presentation yesterday by 2 days ago by South Africa was we want the ceasefire. So they're a call for a ceasefire. So if they're calling back the South African delegation, it may be that they're taking seriously, unlike on January 26th, they're now taking seriously the demand for
the
Israel
ceasefire.
for a ceasefire. I mean, that's my speculation. I could be wrong, obviously.
From a practical point of view, if there's a principal interim relief at this juncture for a ceasefire, as I
Mm.
understand, it doesn't have any kind of prosecutorial powers, but that will then go to the United Nations General Assembly, and of course then to Security Council on that particular issue. And certainly you're probably going to expect a veto from both either the United Kingdom and the United States. So I think it's just simply a more it'll have. You'll kind of have a split that the ICJ will then be in conflict with the Security Council on a core fundamental issue. And that'll be the first time in history where the Security Council disagrees with its own court, well, at least with the UN court, which will be unprecedented in modern history. I just want to take you to one thing which I need to pick your brains on, because you've been asked this so often in the media, and I've seen all your interviews with this character, Piers Morgan, and so on. You inevitably, in most kind of right-leaning media, you are inevitably taken back to what transpired on October 7th. And the discourse has been presented, even in the mainstream media, and I don't know if we have time to share one particular issue. This character by the name of Dr. Phil. He was recently on his show, just recently had an interview with Netanyahu, but he presented the same idea of Hamas burning babies, decapitating babies, and so on. I've seen your response, and particularly the analogy that you've basically drawn with Nat Turner, which is a fantastic analogy, by the way, on that particular issue. But I was curious to know your specific response, particularly to outlets like the Electronic Intifada and the Intercept, which has in fact essentially called out the extremist Zionist atrocity propaganda. I mean, we obviously know there were no beheaded babies, but I mean, even the atrocity propaganda pertaining to rape, you have a situation where Yossi Landau, who's the head of the group called Zaka, he conceded in an interview with Al Jazeera that they were not children. When pressed with the idea of babies being burnt or being burnt in a crib, I mean, this narrative is still reaching out. My question to you is, in light of the New York Times article that Israel apparently knew about what was going to happen a year ago to the date of October 7th, do you possibly not view this, as opposed to viewing it as a blowback by Hamas, but possibly as some kind of at some level, a false flag operation, or at least, I mean, we know Israel is engaged in false flag operations like Operation Lavon and so on. On that day, the security was not operational. It was as if Hamas and whoever was there was allowed to enter. Do you not see something far more deeper? I mean, Israel engaged and invoked the Hannibal Directive where they shot their own hostages. Do you not take that particular position as, do you not view that as a far more meaningful approach to adopt, as opposed to being in a position where we always have to be in the defense to say, look, this is a reality, this was coming, they've been kept in a concentration camp, whereas there's a more sinister element which involves Israel's direct involvement at some level?
There's no evidence for that, and I don't think we should go there.
What about the New York Times article, which spoke about the fact that Israel apparently knew about what was going to happen? They called it Operation Jericho.
Well, there are two things to say about that. Number one, the person who wrote the article, Mr. Bergman, he's basically an Israeli agent on the New York Times. Whether he's paid for it or not, to me, is beside the point. Roland Bergman basically is the Israeli agent along with this Kirshner on the New York Times. Now, Israel obviously suffered a huge blow, not just public relations blow, but a shattering of its image on October 7th. Because Israel, up until that date, it still retained the reputation of being a kind of James Bond state writ large, with these high-tech commando operations which were supposed to awe the entire world. And suddenly on October 7th, its technical prowess, its James Bond-like image, was dealt a shattering blow. That being the case, Israel's capacity to terrorize the Arab world, what Israel calls its deterrence capacity, also suffered a huge blow, because it seemed as if, hey, Israel is not as invincible as we thought it was. So it's not altogether surprising that Roland Bergman would start writing these stories claiming, oh, we knew it all the time because we're omniscient, we're all-knowing, we're the James Bond secret state that knows everything, or at least that's the image they wanted to project with their high-tech prowess. So